Hi, thanks for turning into Law for Doctors, where we share tips and best practices in both law and business to help your healthcare practice succeed. My name is Sarah Clark and I'm the community liaison here at Law for Doctors. Now we're going to hear from our favorite lawyer and host, Leland Fox. Leland?
Thanks, Sarah. This is Leland, your favorite attorney, at least in health and small business. So today we're going to be talking about HIPAA law, but before we do that, I want to introduce our sponsor, Wells Fargo. Wells Fargo wants to help your business and healthcare practice succeed by giving you the financial resources you need to do so. They're a huge fan of healthcare, and that's why they sponsored the show, so we're happy to have them on board. Again, go to Wells Fargo for your financial needs. So let's get on to our topic, which is HIPAA, the Health Insurance Portability and Accountability Act. You'll notice there's two A's in that and not two P's. It's one of my HIPAA pet peeves, if you can have one of them, is I see the two P's a lot of the time. So it's two A's, one P. I teach HIPAA training. I call it HIPAA training for humans because it's made for humans, not for robots. A lot of the training you'll see out there is literally read by robots, so it's something I try and help people learn in a way that's digestible by humans. So let's get started on a program. HIPAA is a creature of law created by Congress. They made HIPAA. Again, you'll see two A's, one P. And HIPAA is overseen by the Health and Human Services Department of the government. And when we talk about HIPAA, there are a lot of aspects to HIPAA, but the main things that we're usually talking about are the security and privacy provisions of HIPAA, which relates to the protected health information of individuals. HIPAA has gone through a lot of changes in the recent years. The first one is the HITECH Act through the American Restoration and Recovery Act, I think. I can't remember what the R's stand for. But the HITECH Act relates to the electronic storage of HIPAA information. So it deals with both security and privacy considerations in the HIPAA law. HITECH also introduced something that's very important, which is the breach regulations of HIPAA. The electronic protected health information provisions of HIPAA. We're going to get to the breach a little later. But the electronic protected health information has required standards. You'll see there's technical, physical, and administrative standards, and addressable standards. So this is kind of where you see what things do you have to do under HIPAA and what things should you consider doing in HIPAA. That's the difference between required and addressable. And as I mentioned, it also introduced breach standards. So this is what happens when there's a breach. There are things for security. If there's a breach of the data that you keep in an electronic format that gets breached, there's provisions related to that, as well as for privacy breaches. One of the main things with the breach law is that they enacted notification rules, meaning that if you breach and you have a certain number of breaches, you have to notify people that those breaches were made. And you see that in the news all the time. Taking a step back, HIPAA only applies to certain covered entities. Not every healthcare provider is going to be a covered entity, although most will be. So if you're not a covered entity, you don't have to worry about HIPAA. But most healthcare entities, again, are going to be a covered entity. The HITECH Act says that business associates are also responsible for following HIPAA laws. But in the business associates under the HITECH Act, the covered entity is still ultimately responsible for the business associates' violations of HIPAA. The inside of the HHS is the Office of the National Coordinator, who coordinates a lot of the security and privacy regulations, specifically dealing with the technical aspects of security and privacy. So the ONC is going to have some guidance and guidelines that you'll want to consider if you're a covered entity. And There is also the Office of Civil Rights. The Office of Civil Rights is the police arm, the enforcement division of the Health and Human Services. So they oversee HIPAA compliance and make sure everyone's doing it. And if they're not, they let you know through fines. So if you do have to notify someone, you're going to have to notify the Office of Civil Rights. And based on what you're telling them, they might get the Department of Justice involved. The Department of Justice gets involved if there's if say you're selling your protected health information on the black market. Well, that's a Department of Justice criminal issue dealing with security and privacy, and their own criminal issues in security and privacy. There are also a slew of other state and federal laws that relate to security and privacy of protected health information that you will have to deal with as a healthcare provider. And recently, the omnibus rule made some changes to HIPAA laws. Notably, the omnibus rule said that business associates are not only responsible for HIPAA, but now they can be fined directly for any violations of HIPAA, whereas before the covered entity was the one that was on the hook. Now business associates are also on the hook. But the omnibus rule made some changes to the security and privacy in addition to affecting the business associates. So, as you can see, my simple diagram of how HIPAA works is not all that simple, and it's a complicated law. In fact, I have here with me, this is the simplification text, and as you can see, it's quite lengthy in its simplified form. So when you're dealing with HIPAA, there are 4 things that you really need to consider and make sure are happening. The first is that you need to have a HIPAA compliance officer in your organization. This is going to be a person who's responsible for making sure all of these things that we've been discussing are addressed, that the required elements of high tech are addressed, and that the addressable aspects of HIPAA are considered. The second thing you need to do is provide training to your compliance officer and to the staff so that they know what's going on, because as we just showed, HIPAA can be a complex area of law. The third thing, and this is something that's available on our website for free at the moment, www.lawfordoctors.net, is you can take a basic HIPAA compliance review. It's a self-audit that will take maybe 15 to 20 minutes, just to go over some of the very basic things that are involved in HIPAA to see, you can get a sense of how you're doing. And the fourth thing is, when you need help, go get it. Law for Doctors, of course, is a resource for you to find HIPAA help when you need it, but you can Google and find all sorts of places that provide HIPAA information. And the government is not trying to keep HIPAA a secret. So you can go on the HHS website, and they'll give you some direction and guidance on HIPAA when you need it as well. So that's something those 4 things are things that you should always have, and if you don't have them, you can do those today. So, Sarah, let's move on to our question and answer portion.
Questions, emailing us at show@lawfordoctors.net, or you can also tweet us at lawfordocs with hashtag AskLeland, and please ask all the questions that you have. We actually have a few questions today. The first one is from Hannah Clark, and she's a nurse, and she's asking, with social media, is it ever okay to mention a patient without using a name or diagnosis?
I'm going to go back to the first thing that I said in my 4-item checklist, is that there should be a security or a HIPAA compliance officer in your organization. And one of the things that they should address is social media. So there should be a social media policy in place in your organization. So if you have questions, the first place to turn to would be your own social media policy. If there's not such a policy, my blanket rule is no, stay off of social media. Don't address patients or identify patients on social media. One of the elements of protected health information is demographic issues. So if you're, say, in a hospital in a small town in Iowa, and you have a picture of an anonymous patient, well, that gives away the demographics of that individual because they know that they were treated in your hospital in Iowa. So that's just something to be aware of. Just stay off of social media if you don't know what your policy is.
Okay, I have another question also from the same person, and she's asking, is it okay to be friends with a patient in a social media site once they are discharged?
And again, this goes back to your social media policy, but as far as being friends with a patient, I mean, you can be friends with whoever you want to be outside of business, but what you're not going to want to do is to disclose that friend who was a patient was treated or what kind of treatment or that they were there. Just keep it friendly and avoid going to the medical aspects of your relationship.
Great. We have another question from Francis Johnson. He tweeted us, what does the HIPAA privacy require of covered entities when they dispose of health information that is protected?
So I like the question. The key part of that question is the word protected. HIPAA law requires you to protect the information when you're disposing of it. So if you're disposing of physical paper, you're going to put it in a secured trash bin that would be collected and shredded so that it'll be unreadable. And there are a lot of companies out there that specialize or provide HIPAA compliant, or they provide services to help with your HIPAA compliance in disposing of your physical health records. Digitally speaking, it's the same thing. You need to have that stored in you basically have to have it encrypted. That's what you want to do because it's going to help you avoid breaches at all if you encrypt your electronic protected health information. So those are the two things: is encryption for your electronic information and shredding your physical paper information.
Our last question today is from Lloyd Christensen, a medical student, and he asks, how will the government know whether I'm compliant or not?
That's a good question. So I said the OCR is the police arm of the HHS. In a way, it's kind of not true. They're the enforcement arm, but there's no HIPAA police really out there. So the way that most people are going to get caught not complying with HIPAA are three things: an employee who maybe you fired or you don't get along with. They're going to notify the OCR that there's a HIPAA problem in your organization. A competitor might want to get you out of business so that they can capture your business. So that you need to be watching out for competitors that might want to report HIPAA breaches. And then, of course, everyone thinks that they know what HIPAA is, and your patients have heard of HIPAA, and they know that you can get fined for it, and they think that they can get some of the money. And so your patients are going to be complaining about HIPAA. And in my opinion, those are the three sources that are really going to make it so the OCR gets you on the radar.
Well, those are all the questions. Don't forget to ask your questions at show at lawfordoctors.net or on Twitter at lawfordocs. And next week, we're going to talk about billing and collection, so ask all the questions that you have about that. Thank you.
Yeah, and once again, a big thank you to our sponsor, who is, as you know, Wells Fargo. Again, if you need any financial assistance for your healthcare practice, I know Wells Fargo will be there for you because they've been there for us and a lot of our clients and people we know. So thanks for tuning in to Law for Doctors, and hopefully we'll see you next time.